Attorney Glahn?
Thank you, Your Honor. Good morning, and may it please the Court. My name is Wilbur Glahn. I represent the plaintiff and appellant Rachel Anderson in this case. At least 5 times since the 1958 statute was passed, this Court has raised issues concerning whether that statute would be constitutional if it were applied retroactively. Nearly 40 years ago, in the DiMario case, this Court said that if such a statute were passed, it would raise a question of the legislature's power to destroy a long-since executed gift of rights that by the terms of the instrument had become irrevocable. Everyone agrees in this case that Anna Child Bird's trust is irrevocable. Chapter 524 of the Acts of 2008 is that statute, and this is that case. Chapter 524 rewrites pre-1958 instruments and mandates the disposition of private property in a particular way to a particular class. It effectively, both legally and practically, creates an irrebuttable or conclusive presumption with respect to what people meant in their pre-1958 instruments.
Well, that's not so, right?
Well, it is, Your Honor, for this reason, as I said, both legally and practically. Legally, what the statute provides is this. It provides that unless the terms of the instrument provide to the contrary, this is the 2008 Act applying the 1958 retroactively, unless the terms of the instrument provide to the contrary, it is presumed under the 2008 statute that the testator desired or intended to include adopted children. Now, if you think about that, the only instances in which this rule of construction would ever apply are those circumstances in which someone has not indicated by the terms of the instrument that they intended to exclude adopted children. Therefore, in effect, it is a conclusive presumption. Furthermore, it is practically a conclusive presumption because of how the legislature dealt with this. The legislature didn't make this statute retroactive for 50 years after it first passed it. I would not concede that it would have been constitutional had it been made retroactively then, but in terms of the reasonableness and equity of this particular law now, clearly by waiting 50 years, if we operate on the assumption that most people don't draft their estate plans until they're in their 30s or 40s, virtually everyone in the class of people who will be affected by this as testators has probably died, or they are in their late 80s or early 90s. So the ability, unlike many of the other cases, the ability of anyone to come in and present reasonable proof that they had the opposite intent has virtually been destroyed. In addition, this statute applies now a presumption to people in the pre-1958 era that was deemed to be reasonable then, and now the court has said, let's take a different presumption, the legislature has said, let's take that presumption and assume that those very same people had exactly the opposite intent. Whereas each one of those presumptions may have been reasonable on their own, taking the second presumption and now applying it to the same group of people who the legislature reasonably concluded had exactly the opposite intent is irrational. Your Honor, if I may just follow up because you look puzzled at my comment. If we operate in the assumption that a presumption is valid, if there is a reasonable relationship between the fact, the actual fact, and the fact presumed, that the legislature concluded for all people prior to 1958 that if they said nothing, they intended to exclude their children.
I wasn't puzzled. I thought it was an interesting point.
Okay. So this statute is unconstitutional for 3 reasons. First, the public interest is not reasonably served by this statute. Secondly, unlike many of the other cases that this court has addressed.
That by itself doesn't matter. I mean, don't you first have to have some interest that's hurt?
Well, the private interest or the public interest, Your Honor?
Well, I mean, it's got to be. Isn't where you start that it is taking away vested rights?
Of course, Your Honor. I would say this case is fundamentally different for exactly that reason. This is the case that the court has indicated in the past would present the problem. There is no question that Rachel Anderson's right, and for that matter, her great-grandmother's right, was a vested property interest. And whether we refer, I'd like to just make a point for the moment that this court has been correct in indicating that property interests don't depend on whether it is, we call it a fully vested interest or equitable contingent interest. They are all property interests. And in fact, this court recognized that when addressing the proviso in the Billings case in 1972. Footnote 10 in that decision cites cases in which the court says, in effect, these are property interests. So in the balancing test, you're absolutely correct, Your Honor. We would say that because this statute affects individual property
Does
interests.
anything in the record indicate how much this trust is worth?
Do I know how much the trust is
Does
worth?
anything in the record indicate?
No, Your Honor. Not that I'm aware of, although we know. No, I do not know. Well, to answer your question more accurately, Your Honor, I'm not aware that there is anything in the agreed statement of facts that has come to this court that would indicate that.
With regard to the vested interest, vested upon death of the testator, I assume is your point.
Well, and in the case of my client, Rachel, vested at her birth.
Okay,
Her
but,
right
but not fixed in terms of the proportion that she would inherit.
Yeah, but that's not the issue, Your Honor. That's effectively the question of saying, if I have $100,000 and you take $50,000 of it from me, that you haven't affected my property interest. True that that her interests could have been affected by the birth of other biological siblings. It could have been affected by the fact that she died prior to her father. However, all of those contingencies are no longer in effect. They all have come to pass. And furthermore, her right, the right to have that property interest, that is her equitable contingent remainder, is one that was a property interest from the moment that her father died and from her birth. In fact, she could sell that interest. She could assign it. The tax
Yes,
code.
but as you say, she could sell it and assign it, but we still don't know. The amount isn't fixed. Wouldn't be fixed.
Well, the amount would be fixed in this case, Your Honor, were it not for the fact that. Sorry, I didn't mean to interrupt. Were it not for the fact.
I was making the point that until the I guess it would be her uncle died without children, right?
Right.
I mean, that changed the amount. She went from she went from 25% to 50%.
25 to 50%, right,
That's
Your Honor.
right. So that wasn't fixed until that death happened.
No, but as this court has pointed out in the DiMario decision and the Dean decision, the, quote, cutting down of an interest by arguing that somehow, as the amici in this case have argued, that somehow simply because she might get less doesn't mean she doesn't get anything, is not a valid basis to affect property interests.
What is the importance of our presumption that a testator knows the law at the time he or she executes a will?
Well, the court has said that it's a significant presumption, that you determine from the facts and circumstances surrounding the testator's intent that the testator is presumed to know what the law is. If you think about what the consequences, so that amici have argued that rules of construction are simply rules of evidence, and they can be changed at any time. If that were true, consider what the consequences that would be to draftsmen of wills. Now you would say, I am not entitled to rely upon the fact that when the testator has died, the rule of construction in place at the time when they drafted the instrument is in place. So the only thing a lawyer could do to protect both himself or herself from a malpractice claim, or to protect the client, would be to include every single contingency in that testamentary document.
Well, this is assuming that is it the great-grandmother or the grandmother?
It's my client's great-grandmother, Your Honor.
That we don't know anything about what she thought about adopted children. We know what the next generation thought about what the document meant, but we don't know what she thought, do we?
Well, Your Honor, I would say that we do.
Because?
And I'd say it for two reasons. One is the law tells us that we know what she intended. As this court said in the Powers case, rules of construction conclude the testator's intent. So we are entitled to presume that Anna Childbird intended to exclude adopted children. Do we know actually what she meant? No. But part of the problem here is we could not determine what her actual intent is today, 70 some odd years after her death, certainly not reasonably, and we can't under this statute because this statute effectively prevents Rachel Anderson from doing that. The last point I want to cover, well, I'd like to go back, Justice Gantz, to the point that you raised, I think, which is the interest, what is the public interest in this case? And the answer is we don't know, because the legislature said nothing. We know there is no particular emergency here, because the legislature passed the statute in 1958, did not at that point decide to make it retroactive. It passed a statute in 1969 and said that statute would not apply to vested interests. It then repealed that statute, so it returned to what this court in the Grosswald case said was a bright line in terms of treating these interests. So we have to make some assumptions, and the only assumption that we have here, we have plenty in the amici, but the guardian for the adopted interest has indicated that the intent here would be to equalize the rights of biological and adopted children. Certainly as applied in this case, it does not do that. It cuts down my client's interest in favor of adopted children. But if you think of what this statute actually does and whether it reasonably addresses that need or that interest in equalization of interest between adopted and biological children, what this statute, the end result of the statute is this. You now have three classes. Those people who drafted their instruments after 1958 and chose to exclude their adopted children were free to do so. Those people who adopted their instruments before 1958 and were specific about excluding adopted children were free to do so and did. It is only those people who relied upon or were able to rely upon and justified, as this court has said, in relying on the rule of construction before 1958. As to those people, they now have no ability to change their mind. This legislation mandates the distribution of their private assets to their heirs. And that's what makes this statute unconstitutional. As my time is just about up, if the court has no other questions, I'll stop.
Thank you.
Thank you.
Attorney Rockwell?
Good morning, Your Honors. May it please the Court, my name is Maria Rockwell, and I represent John Dugan, the guardian ad litem for the biological minor, unborn, and unascertained issue in this case. I first want to address Justice Gantz's question with respect to the importance of the presumption of issue with respect to the testator. Under the Baker-Watson case, a testator or testatrix in this case could rely on the statutorily defined term. Under that case, this court recognized that the testatrix would have had the ability to either adopt the statutorily defined term or choose her own words. However, in this case, with respect to Anna Child Bird, she had no obligation to state on the face of the document that she wanted to exclude children at the time she drafted the document. That was the law. She only had to use the word issue. What the statute does is it imposes an additional burden on Anna Bird Child that was not required Anna Child Bird, that was not required at the time she drafted the instrument. As such, by applying an opposite presumption and depriving her of her right to address that change of law, it is unconstitutional. In 1942, upon Anna's death and upon the allowance of her will and testamentary trust, equitable interests were created. These equitable interests, both present and future, are property rights and always have been considered property rights. This court has recognized the property rights of minors, unborn, and unascertained individuals in these cases. Public policy, as demonstrated by the creation of the Guardian Ad Litem Office, indicates that these equitable interests are property rights to be protected under our law. Finally, as raised in the Attorney General's brief, the UPC expressly indicated that in pre-existing instruments, the UPC would apply. However, the UPC expressly accepted irrevocable instruments for not only the terms, but also rules of constructions and presumptions at the time of its passage.
So let me ask you this. Let's assume that you have a law which changes the presumption, and the testator is still alive, already written the will, but still alive, but does not change the will. Would that new presumption apply because she lived beyond the point in which the presumption had changed?
As a will speaks at death, I would say the new presumption does apply. However, there's concerns with respect to the law in effect at the time an instrument is drafted. In your case, you're talking about a will as opposed to a revocable trust or an irrevocable trust. But a will speaks at death, and this court has always applied the law of the Commonwealth at the time of death. And in this case, we're essentially having different law applied. At the time in 1942, when Anna Childbird passed away, the probate court allowed her will, and the testamentary trust, irrevocable, was brought to life, and the terms of the law as it was there did not include adopted children. Now, after July 1st of 2010, due solely to legislative act, a different substantive law now applies to this trust.
Okay, now let's assume you are right. What do we do with all those persons who had actually applied the new statute? Are they to be subject to suit for having followed the new statute and done what the statute said they should do?
Suit as breach of fiduciary duties with respect to their status as trustees. I think it's within this court's power to craft an exception. That does pose a problem, Your Honor. I do recognize that. However, the focus needs to be, or I would suggest that the focus needs to be whether or not this retroactive application of this statute, which diminishes established and substantial property rights, unconstitutionally infringes not only upon the beneficiaries of this irrevocable trust, but also other trusts, wills, and instruments that were created prior to 1958 when the presumption was changed. I see that my time has expired. If you have no further questions, I would rest on my brief.
Thank you. Attorney Rosenthal?
Good morning, Your Honors. May it please the Court. My name is Stephen Rosenthal. I represent Michael Podolsky, who is the guardian ad litem for the unborn, minor, and unascertained adopted descendants of Anna Childbird. The plaintiff has argued in her brief that the constitutionality of retrospective legislation will be upheld only where the legislation is deemed reasonable, citing the American Manufacturers case from 1978. The plaintiff, however, has inverted the rule. Only retroactive legislation that is deemed to be unreasonable will be held to be unconstitutional. There's a big difference between those two formulations. There is a presumption of constitutionality in the 2009 amendment, as we refer to it in the briefs. The plaintiff has the burden of proving unreasonableness beyond a reasonable doubt and has the burden of showing that there are no conceivable grounds supporting its validity.
Well, don't you first argue that it isn't, you don't even need to do that because it's a rule of evidence? Or?
Well, it is a rule of construction. And the issue of what the effect of that rule is has been addressed both at argument here in prior briefs. You don't have to reach the issue of constitutionality if this court believes that it is simply a rule of construction that does not create property rights.
I'm just trying to decide whether you're not, I know the Attorney General makes that argument, you're not depending on that, though. Is that right? Or
I'm not depending on whether it is a rule of construction.
correct?
Well,
I mean, do you
that is
advance
part of my argument Let's
But
put
it's
it
not
this
what-
way. In
what
the
you're
first
focusing on,
instance,
right.
I'm taking the plaintiff at her word
Okay.
and saying that this is a challenge to the constitutionality of the statute. And any challenge to the constitutionality of any statute must abide by the rules that are set out in American Manufacturers, also explained in the Leibovitz
So,
case.
so what is the principle? The principle is that the legislature can change the meaning of words after the fact, and that new meaning is what is to be applied?
Not necessarily, Justice Gantz. Everyone concedes here, I think, that this is a rule of construction, and that the court, the legislature has the power to change rules of construction. But what we're missing, I think, is the formulation for interpreting wills. There's really a three-part process. The first process is you look at the four corners of the instrument to determine the intent of the testator or the grantor. Secondly, you look at that intent, or you look at the language of the will in the light of the surrounding circumstances. And the case law in Massachusetts is very clear that you're entitled to look at external information such as the amount of the estate, the relationship between the testator and his or her relatives, and so forth. And the third process, the third part of the process, is sort of the default process. If you can't determine the testator's intent from either the four corners of the instrument or the outside circumstances, then you default to the rule of construction. And what we've done here, or what the legislature has done, is said that we're not necessarily changing the meaning of words, we're changing the burden of production in terms of who goes forward on that third part of the process.
So would your argument be the same if the legislature had said instead, we're going to change the 1958 presumption. We're going to now say that with regard to all wills, even those that were executed after 1958, the presumption is that unless you specifically include adopted children, they are to be deemed excluded.
Once again, Justice Gantz, that would only come into effect or decide the issue if intent could not be inferred from the four corners or from attending
But of course,
circumstances.
let's assume the person basically said that the word issue now means adopted children. I used the word issue. We have no clue what the person really meant, any more than we have a clue here as to what Anna meant. But the result would be that although the word included adopted children when the will was executed and when the person died, now it means that they're excluded. Is there not a problem with that? To basically change, I mean, it sort of changes, you're changing the meaning of a word with the consequences implicit in that meaning after the person is dead and after the will is done. The person can't change it.
Well, if we want to get into the meanings of words, let's look at the statute itself. The statute as it existed before the change in 1958 said that the word child would have a certain meaning. It didn't include, the statute did not include the word issue. And if I understand it right, the plaintiff has argued that although the will and trust of Anna Child Bird uses only the word issue, that the word issue is somehow included in the exclusion that remained in effect until 1958. So you could take it back another step and say that rule of construction. Pardon me, Justice Cordy. Just to finish that one sentence, we could say that the rule of construction didn't even come into play in that case because we weren't dealing with the word child. We were dealing with a different word, issue, which has a completely different meaning. There's no presumption that those two words mean the same thing.
Well, is there any uncertainty as to what issue meant prior to 1958? Any uncertainty anywhere as to what it meant in Massachusetts in the connection with executing wills and trusts?
No, it meant lineal descendants. The question is whether that particular word is controlled by the pre-1958 version of the statute.
Okay.
If I may continue.
Well, I'm still trying to figure out what your limiting principle is. I mean, Can the legislature do this with regard to all kinds of words? Can it say that this word means something and then later say, no, it means something quite the opposite? And that can say what's merely a rule of construction, we're now going to apply it, no problem.
Once again, I think you then face the issue of whether that particular statute, that change, is constitutional under the American Manufacturers and Leibovitz test, and it would depend on whether whether a significant interest was being promoted by this change. It would mean it would determine the nature of the rights affected retroactively and the extent and scope of the effect of that change. And I think if the shoe were on the other foot and I were the one arguing against the constitutionality of the type of statute that you are suggesting, Justice Gantz, I would say that the legislative purpose is not significant and in fact would be harmful, more harmful to the general welfare of the populace of the state than otherwise. I think the opposite is the case here, and in fact there is a long history in the legislature of trying to not only promote but equalize the interests of adoptive children on a par with biological children.
Well, that may be, and surely since 1958 that has been plainly the case. But to say now there is this overriding public interest to go back 50-some years and say, forget about that, whatever you intended back then. I mean, that's kind of hard to say that's a public interest.
Well, the legislator...
Sounds to me like a real private interest that's at play here and not a public interest.
The legislature has made a calibrated effort to minimize the harm that might result to people such as the plaintiff in this case. What the legislature has done is, unlike in 1969, where the amendment was made retroactive, but there was some qualifier about whether the rights had vested or not. In this case, in 2009, the legislature has said that that all of the distributions made pursuant to those pre-1958 wills and trusts are okay up to a certain point. And it is only from that point on that the new rule will go into effect, or the new interpretation of the rule go into effect. It doesn't stop the plaintiff from presenting evidence that the testator meant something else, that the intent of the testator meant something else, which is what they've tried to do.
Well, of course, the testator's not around. So what we know is that the testator, when she made out this trust, we can, I think, assume that she was counseled well by good advisors who told her very specifically what issue meant and what issue didn't mean, because it's pretty important. And so why can't this presumption be rebutted by an equally powerful presumption that, knowing what the state of the law was, she chose not to include adopted children?
The problem is, Your Honor, that we're using the rule of construction as the sort of first line of interpretation rather than as the third line of interpretation. And I'm not second-guessing whoever, if anybody, counseled Anna Bird Child in drafting her particular will, but I would think that a conscientious member of the bar would have said, we have to make your intentions clear. And it is only if you don't know what your intention is that we're going to use certain terms, and those terms will be interpreted to have certain meanings. Just a couple of other points if I have a little additional time. The plaintiff, and I think I've addressed this to some extent, the plaintiff is asking this court to use a rule of construction, and they're calling it an irrebuttable presumption of intent. And I would refer you to the Hirschman case in 2008, which says that the rule of construction is the last or as we've called it, the default mode of interpretation. And the plaintiff would have this court believe that you go directly to the rule of construction without determining what the intent of the testator is from the four corners of the instrument or the attendant circumstances. There is some suggestion by the plaintiff that the intention of the testator is somehow determined by looking at the intentions of wills and trusts that were created some 35 years later by Anna Bird Child's daughter. But I don't think that's sufficient in this case, largely for the reason that Justice Botsford mentioned, that we don't know how the parties are being affected by these changes. We don't know how much money was in the original trust. We don't know how the money was being dispersed or what amounts. And we certainly don't know whether, as the plaintiff suggests, the subsequent trust somehow made up for the original one.
Just one question. I haven't read them, but there are a number of cases cited from other jurisdictions which are described as upholding similar statutes. Is that correct? And do you know how many states have done that?
I do not. The Attorney General listed a number of such cases in her amicus brief, and I would refer you to those.
Thank you.
Thank you, Your Honors.